The Trump administration finally responded to the Supreme Court Second Amendment Preservation Act challenge, which is pending in front of them. And here the Trump administration continues to argue against the state law. They claim it's invalid and that the court should deny review. However, at the same time, they state that they will drop some of this case once it gets back in the hands of the lower court. So very interesting what the Trump administration has now decided to do in the SAPA case. So let's break down what just happened. Now, before we jump into this video, if you guys want to support the channel for free, please consider subscribing to the channel. That of course helps it to grow. And then just drop a positive comment down below because that tells the algorithm that you appreciate this type of two-way content and it should share it to more people. Now, in this video, we're going to be talking about a significant Second Amendment protection case, which is once again back in front of the Supreme Court. This is a case dealing with a state's Second Amendment Preservation Act, or their SAPA law that they put in place. We've discussed this case before because recently the Supreme Court issued an 8-1 emergency order and it denied a stay which would have protected Missouri's SAPA law. This case is now back in front of the Supreme Court and the court will now consider whether they want to grant review to this case and address two-way sanctuary laws. However, the Trump administration just filed their response to this case and they filed after stalling for a few months. However, the Trump administration continues to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. However, at the same time, like I mentioned, they state that if the court denies review, the federal government here will release some of the judgments that they received at the lower court level. And once the lower court gets this back in their hands, they're going to drop some of this and kind of resolve this at the lower court level. Now, this lawsuit here revolves around a 2021 Second Amendment Preservation Act passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce some of the federal laws which violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents and federal offices who are attempting to enforce those inconsistent federal laws which violate the Second Amendment. The law also created a civil remedy where anyone, a resident of the state of Missouri, could sue a Missouri official if that official helped to enforce an inconsistent federal law which violated the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of the state and its officers. So really a lot of the power was in the individuals to file civil suits. In this case, the district court on review ruled in favor of the then Biden administration, striking down the Missouri Preservation Act in its entirety. So the scope of relief that they granted was against the entire SAPA law. Now that's important for some of the things that the Trump administration is now saying in their Supreme Court response. Now, in response to that, the state of Missouri appealed to the 8th Circuit. Missouri at that time wanted an emergency temporary stay on the lower court's total relief, which was granted against the SAPA law. And eventually that made its way to the Supreme Court, and they were asking for the Supreme Court to intervene on an emergency basis and issue a stay against that total relief, which was granted by the lower court. However, on review, the Supreme Court went against the state of Missouri and issued an 8-1 order denying that emergency request for a stay. Now, after that, the 8th Circuit had this back in their hands and they actually held oral arguments in this case. However, ultimately, once again, they ruled in favor of the Biden administration. But now Missouri has filed their writ of cert to the Supreme Court on the merits, and they're asking for the Supreme Court to review this entire issue. One of the big things that Missouri points out in their petition is that the 8th Circuit essentially said that the structure and potential operation of the SAPA law is valid, but ultimately they struck it down because of the underlying purpose, which was the Second Amendment. Missouri also argues that the 8th Circuit went against clear precedent and found that state officials could still be sued because the court there believed that the state and its officials played some sort of enforcement role by simply not enforcing certain federal laws. Essentially, they found compliance and non-action under the SAPA law was still enforcement. So non-enforcement was still enforcement. Now, this law was originally opposed by the Biden administration, but now the Trump administration has controlled the case. And initially, they stalled their response out for multiple months in the Supreme Court. And they were saying that they wanted to review this and determine how they wanted to handle it. I'm sure the 2A task force also got involved in this. But now they filed their response, and the Trump administration continues to argue that the SAPA law is invalid in most of its applications, and that the lower court, got the decision right, and the Supreme Court should deny review to this case. However, at the same time, they argue that if the Supreme Court denies review and this gets back in the hands of the district court, the Trump administration, the federal government here, will ultimately dismiss some of the judgment that they won at the lower court level because they're arguing that the scope of relief that was granted by the lower court was too far and it needs to be narrowed. They argue in their response to the Supreme Court that Petitioners argue that the United States lacks Article 3 standing to challenge the act, and that the United States lacks a cause of action, and that the act complies with the Constitution. None of those contentions are correct. The United States plainly has Article 3 standing and a cause of action to litigate the claim that the act is unconstitutional because the act discriminates against federal officials and impairs the enforcement of federal laws. And for the same reason, at least some of the act's provisions clearly violates the Supremacy Clause. So they continue to argue that this is a valid lawsuit that was brought by the federal government and that the Supreme Court here should deny review. But they also then pivot, and in the response they state that while Missouri's objections are flawed, the constitutionality of some of the act's provisions raise more difficult questions than the Eighth Circuit recognized. In following the change in administration, the United States has decided it no longer wishes to challenge those provisions in this pre-enforcement posture. Accordingly, once the district court regains jurisdiction over this case, the United States would not oppose a motion by the state of Missouri under Federal Rules of Civil Procedure 60B, asking the district court to narrow the scope of relief because the United States is releasing its judgment in part. In these circumstances where the state's arguments are meritless and the potentially problematic aspects of the judgment lack prospective significance, the petition for writ of cert should be denied. They indicate also in the response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the court that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture and about how certain provisions of the act will be applied and about whether the provisions on which the Eighth Circuit focused is indeed inseparable from the rest of the act. Given these concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment under the Federal Rules of Civil Procedure 60B when the district court regains jurisdiction over this case. The United States intends to release the judgment except as to the act's plainly unconstitutional provisions identified above, to the extent those provisions purport to apply to the federal government or to require state agencies to obstruct the enforcement of federal laws. The concerns raised here by the United States, however, do not warrant this court's review in this case. The state has not made an argument along the lines in this petition, and this issue arises only due to the unusual scope of Missouri's law. Indeed, if the state wishes to withhold assistance in enforcing federal laws, it could amend and limit the act even under the Eighth Circuit's decision. Meanwhile, for the reasons discussed, petitioners' jurisdictional and merits objections are incorrect, and it is undisputable that the injunction below properly covered at least certain provisions of the act. So after stalling this case for a few months, the Trump administration has responded by continuing to argue that some of the SAPA law is still invalid and that some of the lower court's decision was proper and they properly enjoined some of the SAPA application. They also argue that the Supreme Court should deny review to this case. However, like I mentioned, at the same time, the administration believes that the pre-enforcement judgment in the entire scope, striking down the SAPA law entirely, was too far, that win for the federal government was too far, that they should not have granted that, and that once this gets back in the hands of the district court, the federal government is going to release some of that judgment. They're going to say, hey, we don't want an entire pre-enforcement block on the entire SAPA law. We're going to concede some of this. We're going to let some of this go. And, that would cover some of the SAPA law, but not all of it. So this is a very interesting approach, and I think ultimately the Supreme Court may side with the Trump administration and deny review to the SAPA case. Now they kind of have an out, and they have an easy way to punt this back to the lower court and kind of let the parties resolve this down below, and you dispute about the scope of relief and what should be blocked and what should not. Now, we're going to keep our eyes on this to see how this happens because, again, this is a critical SAPA issue. It deals with state sanctuary laws, but I think there's kind of an easy way out now for the Supreme Court. This dealt kind of with pre-enforcement injunctions. This was an entire block on the SAPA law, but now you have the Trump administration saying that we still believe that some of the application of SAPA is unconstitutional, but we're willing to let go of the entire block on SAPA. We're going to let the lower court here release some of the judgment, or they're going to release some of the judgment, and they're going to let the state of Missouri, file a motion and say that some of the application of SAPA is valid, and they're going to litigate this further down below. So that's kind of what I think is going to happen. That's some of the arguments made by the Trump administration. And again, I think it's an easy way out for the Supreme Court to punt this case if they want. So again, we're going to keep our eyes on this to see how this develops, but that's just what happened in the critical SAPA case, which is in front of the Supreme Court. That's how the Trump administration has responded after stalling for multiple months. And as we get more information, as this develops, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.